Good morning, everyone. I'm so delighted that all of you are here for today's webinar. And today's session will help you better understand the documentation, legal formalities, and the processes involved in real estate transactions. We are delighted to have Dr. Abhishek Sharma, partner at Lex Terrae, as our speaker for today. Dr. Sharma is an experienced legal professional with extensive expertise in real estate law and property-related legal matters. We are so excited to have him here. And here's how today's session will flow. We'll begin with a few opening remarks from Dr. Abhishek Sharma, where he'll share an overview of the real estate documentation and the legal formalities. Post that, we'll move to the live Q&A session, where you can ask your questions by either unmuting yourself or typing them in the chat box. The session will last for approximately 45 minutes, and we'll wrap up after a few key takeaways. So without further ado, let's get started. Over to you, Dr. Abhishek.
Yeah. Good morning to one and all. Thank you, Ms. Pooja, for your very kind words of introduction. And also thank you, Manoj sir, for having patiently waited for me to come and join. I'm extremely happy to be spending this Sunday morning amidst all of you because I believe that time is a valuable thing. And if you have taken time out of your Sunday schedule to join here, it really means a lot of your commitment towards coming here, and I'm eagerly looking forward to share my thoughts. When we were discussing with Manoj sir, he just wanted me to discuss about a topic which he felt is something which is problematic, or he said that generally he come with his very expertised consultancy. He has handled many successful projects, and he when we met for the first time and even thereafter, he was telling me that people continue to have a lot of confusions about the way how documents are prepared or what kind of documents to be referred. If there's a document which is missing, how do we cure the defect? So during the discussion, he suggested, why not we initiate a discussion about understanding what is important, what is not important, and that's when we came to an understanding that we do this topic. So I'm so glad that I was able to, I'm able to meet all of you here and to share my thoughts about this particular topic. As I was just discussing, due to many reasons, it could be economical reasons, it could be societal reasons or political reasons. Land has always been the most cherished asset that every individual has always wanted to, own. I hope I'm audible. Can somebody please confirm? Okay, great. Yeah.
Yes, sure.
It's my sincere request. If at any point of time I'm not audible, please take the liberty to, let me know about it. And also, if there's something that you want me to repeat, kindly take the liberty to please stop me and ask me for repeating. I'll be more than happy to, repeat. And further, I don't generally have the habit of doing PowerPoint presentations unless it's an academic session to the students or to some training program. So since I'm here to open my heart and discuss with you and get to know your understanding and share, I thought let us keep it a very informal presentation where I share my thoughts. I'm just going to take you through some important documents, and I'll just share some experiences which I have been able to handle in my limited number of years of experience and what I've learned from them. As I was telling you, so land is something which everybody has cherished to, always own. Now, land we want to own. It can be in any form. It can be a plot, it can be an apartment, it can be an independent house. And the reason why you want to own also is something your personal choice. You could want to own it for your own benefit, or it could be a requirement. You may need a house to stay, or it could be for an investment where you have some money, where you have some funds to be parked for investment. So, it became a point of time where government started realizing that land is, though it is immobile, it cannot move by itself. It has the capacity to generate revenue. And government sensed that, if this land without moving has the potential to generate revenue, and that revenue is something which is perennial, it keeps continuing. You may not be interested with the land, or you may purchase the land and you may leave it unattended, you may not do any development. But that does not stop the land from appreciating its value, or that does not stop the apartment from, getting the value increased. So government sensed, why should we leave this asset untapped for generating some revenue for us? So that is when they started levying taxes. So you look around any country's history, be it the Asian civilization, be it the European or American, or any civilization of that matter of fact on this globe. Or even if you look at the aspects of, the novels, history, poets, all of those things, you always see that governments, authorities, kings have always levied taxes. So the first aspect of regulating any real estate asset, be it land or apartment house, starts with the government intervention. So whether you want it or not want it, once the government has an eye on your assets in the form of land and apartment, that becomes the first point of, the regulation. So that is one point. So once government recognizes it to be an asset, they will levy some taxes you continue to pay. So that is on one hand. Second thing is, since land has the inherent quality to appreciate in terms of value, without you doing anything, there's a difference. There are certain form of professions, there are certain form of businesses or certain form of investments where you need to put in lot of efforts. Let's say you're a doctor, you have to study the curriculum prescribed to become a doctor. You should undergo the training. You should be able to, do an internship or a job, or get a training done. Then you'll work in a hospital. Maybe then you branch out to become an independent doctor. Then you'll become successful. So you see, by the time you call yourself an established doctor, you have to put in so much of, hard work, efforts, and build up your skills in order to enhance the value of your services, in order to enhance the value of a professional profile. This applies equally to any business. I'm sure even Agarwal Estates today is a pioneer in this field, not because of 1 or 2 days. Manoj Agarwal, when he came back from US, had a vision, had a commitment that he wanted to change the way how real estate transactions happen. He wanted to bring transparency. I'm sure he must have had very tough time convincing people about bringing orderliness, bringing systematicness, and then he had a good team, and he was able to build that amount of reputation today what they're enjoying because of the sustained hard work. So it didn't come to him just a matter of 1 or 2 years. I'm sure all the team here will agree with me the efforts what you have contributed. But if you see, as against this, be it profession, be it employment, which requires a lot of efforts, for a land or for an apartment or for a house, you don't have to do anything. Just buy it and keep it, it appreciates itself. So what happens? It becomes a very easy and a very attractive form of investment for anybody. You don't have to do anything to it. You take an agriculture and you must be cultivating it. If you take a non-agriculture, even if you don't cultivate it, it's just going to increase value about it. So the accessibility and the requisite skills were so less for people to invest on land, became so easy that everybody started investing more and more amount of money, or started trading land, or started doing business involving real estate. So please understand, even today, real estate is one type of profession which is completely organized, at the same time completely unorganized. Completely organized because people like you are consultants, or people like Manoj Agarwal has been able to run an organization systematic manner with putting all the efforts. You will still also see in the same spectrum on the other end, you will also see people who are completely unorganized, who don't follow any procedures, who don't follow any proper documentation work, but yet end up, selling lands, yet end up selling apartments, yet end up doing some, reinvestments, transactions about the sale of an apartment or something of that sort. So it is that one classic type of an example where people with skill also can sustain, people without skill also can sustain, but not for a longer period of time. So coming back, so one point is it is easy, anybody to it, and it's also not very complicated. See, everybody knows that you invest money in land today, it will multiply. So everybody and anybody who has the source of funds would want to do an investment about it. So the possibility of doing lot of transactions on land is very much happening. That's the reason why you pick up any piece of land and you just try to understand the flow of title from the original person who owned the land to the person with whom you're trying to deal. It would have, in any instance, easily changing of hands will be about 2 to 4 people. On any given transaction, you get to see two to four people would have, that is, one person would have bought from the government, he or she would have given it on a loan, they would have repaid that loan. They will get they will get the property taken out of the bank custody. They will then try to sell it to another person. Other person will hold it for some time. Due to some reason, they will sell it, and you would be the third or the fourth person. So on any transaction, you see that it is very rare
Abhishek,
that you end up becoming. Am I audible? Any questions still here?
एक मिनट
Okay.
सर लाइक अपना
Okay, I could hear some disturbance. Okay, sorry. Yeah, so on any real estate transaction that you get to see or you review, you end up getting to see that one or two hands would have definitely changed. So that is because, as I told you, somebody might be doing transactions on the real estate property what they own, maybe due to their personal requirement, like taking bank loan for some other purposes, or somebody might be selling it because they may need funds to do some reinvestment, or somebody might be selling because there may be an urgency of funds they will be doing about it. Given whatever could be the reasons, it is going to have a lot of transactions. So one is we understood it has inherent value to generate. It doesn't require too much of skill sets. People tend to invest more because it's an easy form of asset that is very much there available with you as long as you can arrange for funds. And third thing is it is completely tradable. So it is, there may be difficulties in you trying to trade a stock, trying to trade a mutual fund, trying to, trade or do business with gold. But any person, even with limited knowledge, also will be in a position to trade or make a deal with the real estate asset. That is because of the that is because of the simple procedure involved about it. Now, because of this lot of transactions, and coupled with the first point, what I said about government regulating by way of collecting taxes, there is a reason why we have so many documentation. So now I'm trying to come to the topic of discussion what we have in today as to why we end up seeing so many documentation. You will see that the whole process of documenting every single transaction relating to real estate asset is not something that is happening in India or happening in any other part of the globe for the first time. It has been a practice for a very long period of time. So it could be a land allotted by a king to another person in recognition of service. It could be a land which could be allotted to an ex-army service member. It could be a land which a person might have got due to some social welfare scheme. It could be a land which a person must have got as a compensation. So you get an entry there, and then that person will try to cultivate some agricultural crops on it. Maybe during the passage of time, agriculture would not be feasible. They will convert it to non-agriculture. Then they will try to make a layout out of it. They will take permission from the government to make a layout, and then they propose to make a development of flats on that. They will end up getting into a joint development agreement. They will be flats constructed. There will be sale agreement. So unusual, I mean, a very any other regular type of real estate transaction in any given day would easily involve not less than 4 to 6 transactions that has happened in that particular with reference to that particular property. And each of this transaction can have some documented proof, and the documented proof can be around some 50 to 60 pages, or some instances could be around 100 to 150 pages. So the bulk amount of paper, what you always get to see with relation to any property is because of the government requirements. It's because of the regulatory requirements which has compelled every single transaction that has been done with relation to that property to become documented. Now it is in a way good because please understand, let's say I'm staying in a house which was allotted to one gentleman by way of the Army Welfare Board. Now the gentleman, wanted to use some funds for his personal reasons, then goes on to take a permission from the Army Welfare Board to allow him to sell because there are certain type of lands, which are allotted to you through social welfare schemes or allotted to you because of some special services that you have rendered. You will not have an option to sell them. It is given to you as a recognition. You cannot be earning a profit out of it. So let's imagine that this land was allotted to that ex-service member, with a condition that he should not sell it, but he needs some funds. So then he'll go back to the Army Welfare Board requesting him to give him permission to sell. And let's say that gentleman sells it to another person, the other person buys it, and the other person who bought, that is a purchaser, wanted some loan, didn't have any assets. will go and pledge these papers with the bank to take a loan. Now that transaction gets recorded. Now he will have to repay that loan. Now the loan is repaid, then the bank will give back those title deeds or the paper documents. That gets recorded. And then he wanted to sell it to my grandfather. Then my grandfather takes it up. That is recorded. And then my grandfather, before he died, he wanted to make a gift of this land to my father. Now that gets recorded. And then during subsistence of my father's lifetime, he wants to make a gift it to me or to my sister. Now he does it. He did that gets recorded. You see, the reason why we record all of those things is, let's say after I get this property, I want to sell it to somebody, let's say to Manoj Agarwal himself. Now, obviously, he would want to know who all have touched hands on this particular property. Now, my grandfather is not there. The second purchaser is not there. The first member of armed forces for whom the land was granted is not there. So none of these three people who have enjoyed some benefits on this land are not alive. But I am telling that, this land has originally come to him. So obviously you'll have a doubt as to what is the proof. So now when you go back and open those property papers, you will be able to see all the entries reflected relating to that particular land. So even if people who have done the transaction are not alive, even if people who have done the transaction are not available for you to seek clarification or to give you some understanding, the papers and the transactions being recorded have always helped people to have clarity and to understand what is the flow of the title for that particular real estate asset, and thereon they've got it and understood themselves and it has happened. So in a way, documenting all transactions is always very good, because if there's any clarification to be required, you will know whom to go and approach, or at least you will be able to understand that these are all events have happened on this particular piece of land. So in this way, whether we like it or not like it, due to many reasons that transactions are documented about it. So I've just spoken to you about the reason. I've spoken to you about the process. Now let me tell you what kind of papers you're going to get to see, and what is it that you should look when you're getting to review. Let's say somebody out here who's taken time to attend this session wants to buy an apartment, maybe developed by a very prominent developer, and they've approached Agarwal for consultants for their services. And Agarwal has a booklet prepared, and they give the booklet to the prospective customer and tell, this is the papers what we have with regard to the apartment what you're looking for, and please review that. So now you take a booklet, it has so many papers. Obviously, it will definitely have the project brochure, or maybe some amount of document explaining what this project is all about, who is the developer, what are the amenities, how many flats are there, what is the location of this particular project. You'll have all of those important details. Second, you'll have the commercial terms. What is the cost of it? What is the breakup? And third, you will have the standard template relating to the agreement to sale and the sale deed. Fourth is going to be the very important, which is a compilation of all the documents relating to that particular paper, relating to that particular apartment, flat, or villa, or whatever it is. Now here, if you see the first three things, the brochure or the project details, other commercial terms, standard template, is something which we'll be able to understand because it is written in English. We'll be able to understand. But the fourth one, which is a compilation of the papers relating to the flow of title, is something which is very voluminous, and also it may be in the vernacular language. Let's say you're planning to buy an apartment in Bangalore or developed by a prominent developer. Now, developer may be somebody from outside Bangalore. Owner might be somebody from outside the Bangalore, but the land is in Karnataka. The records would be maintained in the vernacular language or the official language as followed and spoken in Karnataka, which is Kannada. So all the old transactions that have been done with relating to that particular land will inevitably be in the local language itself. That is the first thing. Second thing is certain formalities, certain procedural aspects would have been done with regard to that particular land, with specific reference to the type of local laws prevailing. For example, we had what is called as Inam abolition. Inam abolition is basically during the pre-British time, we had kings, we had emperors, we had these small towns and kingdoms which are owned by kings. They had control over a certain geographical region. Everything that came under that geographical region belonged to them. They would give it on rent, they would give it on lease. After we got independence, we became republic. That is no longer any sort of kingship. We became a democratic country. So all the kings and emperors were asked to surrender all of their lands to the government because government became a sovereign authority. So you will have, and the way how, so some in some states, when the kings gave back their lands to the government, either they were given compensation in the form of money, or certain instances are there where the government gave them, alternative lands in other places. So, so there could be some transaction where you may be looking at buying an apartment on a piece of land which is given to a particular person in compensation for having surrendered a land. Or let's say, for example, some gentleman owned a piece of land and metro construction was happening. So the government has had asked him to, release his land. And in alternative, when they offered him money, he said no. But then they offered him some land that was given outskirts of Bangalore. So he took that land and now he wants to develop that land into an apartment. So like this, you see there may be certain improvements, some developments that might have been done to the land, which again may be due to the local requirements. Some of which may be recorded down in English, some of which may not be recorded down in English. So the fourth part of the project papers that I told you compilation will have so many information. Sometimes you will have so much of information that you will not know which of this is to be considered, which of this is not to be considered. Because information is important, but excess information becomes confusing, deficit information becomes suspicious. When somebody gives you something which somebody does not give you for what you're looking for, you tend to have a doubt. You tend to suspect, okay, why is this person not giving me what I'm asking for? At the same time, when somebody gives you more information, more than what you're asking, more than what you're looking for, then you also become suspicious, wondering why is this person giving so much of information? Why is he or she trying to flood this much of information? So majority of the times, what I have understood from my experience is that many of the clients who walk to me for asking advices on investment, asking advices with relating to the personal choice of making, purchasing an apartment for their dwelling purpose or anything about it, are almost caught with the problem of not understanding how to read these documents. Or, okay, nowadays you have got advanced tools. Even if it is written in a language which you don't understand, you have advanced tools that can translate it. I myself use certain tools. I know only a few languages what is spoken in India. Let's say one of my client wants to buy a land in Chennai and the papers are in Tamil. I don't understand. I mean, I may be in a position to understand, but I cannot read Tamil. Some documents are written in that particular language. We all are fortunate to have tools which can help you to translate it. But please understand, translation can be done, but you will still need the help of a person who knows the language to understand what is the transaction all about. What was the reason for the transaction? In what context was the transaction? Because it is not just knowing about the fact. Like I said in the example that I gave you about my house, you know, so why, for example, if you ever were to look at the documents of my house, you will first see an allotment letter given to an army brigadier, given by the Army Welfare Board. Subsequently, after some years, you also get to see a no objection letter given by the same Army Welfare Board. Now, if you see that no objection letter, you only say that it is given to a permit so and so brigadier to sell that one. But nobody knows what is the process. Nobody knows why was that process taken, why was that NOC taken. Subsequently, you will see one sale deed. You will then see one mortgage deed. You will then see one discharge deed. Now, why is that? Why did that mortgage deed come? Who executed that mortgage deed? Why was that done? Who paid that loan? Why was that discharge done? Who entered into the discharge deed? So what happens nowadays is we know the documents. We're able to see the documents. We're able to understand the contents of documents. But where we are lacking is trying to understand the factual matrix, the context in which the transaction happened. So please understand, it is not just sufficient for you to know what all have been the transactions that has happened in relation to that particular piece of land, flat, apartment that you're looking for. It's equally important for you to understand what all contextual transactions are, in what context the transaction happened, because that will help you determine the extent of responsibility. Let's say, for example, I gave an example where, let's say, my grandfather gifted this land to my father. Now, let's say instead of gifting, if he had made a partition, okay, let's imagine that he had two female children and one male child, and let's say he decides to make a partition, and he includes only my father being the only male child, and he excludes both my aunt, and you get to see that partition deed. You understand that yes, there's a partition deed, but what you must also understand is that why was that partition deed done only with one male child, when in records it is shown that there are two more female child. So you'll have to ask a question whether those two female child were they given anything in lieu of this partition, or did you give them anything else. You must also read the document to understand whether those female children are given a no objection, because you never know, they can always come back. Let's say, for example, after my grandfather died, and let's say when my father proposes to sell this house to somebody else, my aunt and her children can come and object, telling it is my grandfather's property and he did it. Let's say my aunt is not there and her children are there, which is basically my brothers and cousins. They can come out and tell that we object for this land to be sold because we also have a share. Our mothers had a share. Our mother was not considered, so we object for this partition. So it's important for you to understand that every single transaction that has happened on a real estate asset would have had a history behind it. You need to know what is a history. You need to know who all were involved in the transaction. You need to know why did they involve. And if somebody is related to that, you also need to know why were they not involved. Get a clarification about it so that you not just know the entries, you also know the factual background. So this is one type of understanding that we get to see when we look at the narration. So I'm summing up again my point. What I was trying to tell you is that, when you start reviewing the papers relating to the title, just to clarify yourself, it's important for you to know, to keep a track, know or note down all the transactions, note down, try to get all the copies of all the documents which have related to the transactions, know who are all the parties involved, most importantly, know the relation between each party, and then try to make an assessment. These are all documented transactions. See, please understand, if the partition deed which my grandfather does with my father is documented, then you can understand from the revenue records or from property records. So then you can question as to why were the sisters not involved? Why were the female children were not involved? But please understand, in Bangalore and also in many other places, when you start reviewing the papers, you will get to see that the number of transactions what you're seeing, which are documented, are not the only one. There may be many more multiple transactions which might have also occurred on that particular land or that apartment or that sale, which may have gone unaccounted, which might have not reduced into writing, which would not have registered. That is something which is very complicated, because if it is a registered transaction, it reflects, because you go to the government office, you register the deed or the document, and in the revenue records or in the government portal, you know that on that piece of land, these are all the transactions, these are the documents, these are the people. So you know that one. But how do you track those transactions which have happened in private capacity? Let's say, for example, in the same scenario that I gave you about my house. Let's say, due to some financial reasons, my father wanted to borrow some loan and he did not want to go to a bank or an institution. What he does is he goes to meet his brother-in-law, that is his sister's husband, who is economically in a very good position, and he says, I need about 10 lakh rupees for starting my own business. In return, or just to guarantee the payment of the loan, what you have paid to me, you please keep these papers belonging to my house. Now, this is a private transaction. And imagine a situation where he does this without keeping me, or that is me and my mother and my sister. Only he would know about it. And even if my uncle, that is my father's brother-in-law, also does it in a very secret, discreet manner, only he would know. So none from my aunt's family would know about this, none from my family would know about it. Let's say due to some unfortunate reason, my father is unable to pay, and then he's transferred the land into my uncle's name, in his own capacity. And then when I propose to sell this land, I also get to know that only this has happened. So many a times what happens is you will also have to know about the unaccounted transactions or unrecorded transactions. Now that's the most difficult thing. And I must say it only comes with good faith. You will have to ask the owner to confess if there's anything that they know about it. And another thing is what now coming to the way how we narrate the document. So now when you have collected all the documents and when you propose to, make a sale deed or an agreement to sale, it's important that you put the obligation on the part of the seller to be bound with any problems that may arise with regard to the land apartment that you're planning to buy. So I'm sure if at all you have ever read a sale deed, there is something what is called as covenant. Covenant in the legal language is what is called as undertaking. So you have certain covenants or undertakings which the seller does or seller says. And there are certain covenants or undertakings which the buyer does. Now, typically the seller covenants or seller undertakes declare that, he or she is the absolute owner of that particular apartment or that land, and he or she has the title to sell, dispose, whatever they want to do with the land. And they also say one more thing, they have the right marketable title. So when this is a very important term that I'm sure you must have all heard or come across. This marketable title is what it means is that they have all the authority, they're entitled to deal with this property in the way that they want. That is independent power to take a decision to either sell it, gift it, write it as a piece of will to somebody whom they want to give to be given after their day, or take a loan on that. So to get this power, you must should not have any sort of obligations attached to that particular piece of land. For example, if you've taken a loan on your house and you've deposited your title deeds with the bank, you will not have a marketable title because you have given your land, you have given your house as a pledge. It's a mortgage. So subsistence of loan when you don't have the proper title deeds. Okay, even if you have managed to keep the original title deeds with you and not with the bank, and let's say you try to strike a deal with the buyer, and it can become a problematic because you cannot declare that you have a marketable title because on your house, on the right that you claim you have over your house, there is a condition that the bank has to clear. That is, you have to clear the loan before you get the complete right. So the clear marketable title is something that you have to get by yourself. And you must do any transaction relating to real estate only with such kind of people, entities, companies, developers who have that entitlement, who have that marketable title. It's a very wide term. All that I can tell you in very simple words is, do they have the power? Do they have the right? Are they permitted by law to do the transaction which they're proposing to do is what that matters. Any slightest, disturbance, any slight condition on them which says, you cannot sell because you have not paid the loan. You cannot sell because you have pledged this. You cannot sell because there is a municipal tax which has not been paid. This will come in your way in not allowing you to deal with the property in a way that you want it to be dealt.
I think somebody has raised that, Mr.
Yeah,
Krishna
yeah,
Verma.
please. Yeah.
Okay, can I ask?
Yeah, please, sir, go ahead.
Yeah. No, there are two things. One is with regard to the reps and warranties by the seller and the corresponding indemnity with regard to the title that he indemnifies if there is any defect in title in future. Okay,
Yes.
that's one thing. Another is devolution. The death of the original owner that the property then vests with the legal representatives. The problem in Karnataka is that we don't get a legal heir certificate. And only things that we usually see is the family tree. Suppose I have three, four brothers, and only two or three go to the Bangalore office or the revenue office and get the family tree affidavit done and family tree signed. And subsequently, after purchase, then it may so happen that there are few other legal heirs who are excluded intentionally or otherwise by the other two legal heirs. So in such a situation, what do you do? One. The second is the indemnity regarding defective title. That the seller says that in future I will indemnify if there is any defect in title. So what happens? So the once I sell my property, this will be a continuous responsibility on the seller. To what extent?
Okay, yes, sir. Yeah, I'll tell you. This is a very, as he rightly said, the problem of creating a family tree, or what we call as genealogical tree, is very much prevalent not only in Bangalore but also in other metropolitan cities. Even in Hyderabad also. I think in Chennai it is little systematic, but it is still yet to go. So what happens is that there are two ways of creating family tree. One way is to go to the Bangalore One Center or the Revenue Department and make an affidavit. That is, affidavit is self-declaratory. That you say that you are the son of so and so, and that your parents are these many. Your parents are, the mother and the father, their name, Aadhaar, and PAN. And then you say that, to your parents, along with you, these are the sibling details about it. And then you complete your generation line, and then you come to your spouse details, and then your children. Similarly, you also see about the spouse details of your siblings and then their children. So rightly said, it is not verified. Okay, it is self-declaratory, like how we file income tax on self-assessment, like how you compute your own incomes and then file the tax, and later on, government does their own job of verification if it is required. In the case of family tree, also this has happened, and many a times, like he rightly said, there have been instances where deliberately they have left out, the problematic siblings or the problematic parents or the problematic spouses, thinking that they may do about it. That is another unfortunate event that is actually happening. Of course, nowadays what we see a trend is the revenue department is insisting on verifying this. So they're asking they're asking us to verify through multiple methods, they're planning to do a door-to-door check and do all of those manual way of techniques of verification, but that may not really be sufficient enough.
Correct.
If you want, if you wanted to be full more proof, let's say you're planning to buy a land from a joint family and you want to be convinced about all the members being bought on record, and you know who is there, who is not there. One way is to insist them to go and get if at all, let's say the joint family is there and the parents are not there. One of the parent is there and the other parent is not there. You can ask them to get a succession certificate. Now, succession certificate or a legal heir certificate is another option that will be done through the court. So the surviving legal heirs will have to go to the court and say that they belong to this parent.
No,
One of the
that is,
parent
I agree. I agree. But succession certificate, it takes usually at least 6 months. And
Yes,
in
yes.
and we don't in Karnataka, they issue legal heir certificate only
Yes,
for the government employees or
yes.
whoever government employees. So
And
if
I mean, yeah,
yeah,
just to clarify you too, sir. Yes, like you said rightly, in Karnataka you get legal hair, but it is not limited only to government employees or government purposes. You can apply. Of course, additional condition would be you have to tell why you want to apply. For example, there may be a fixed deposit for which there is no nominee. There could be a joint bank account which there is no nominee. And maybe along with taking NOC, the bank is also asking you to get a legal aid certificate. So the court is very much concerned to know under what context are you coming before them to go in to get a legal aid certificate. So, like you said, I mean, I know it is time bound and it is time consuming, but that's the only available alternate remedy if you don't want to rely upon an affidavit driven family tree. Again, legal aid certificate is also not foolproof. There also you can somehow convince and manage to not to draw the court's attention to everybody. So that brings me to the second question, like you said, to what extent does the seller indemnity continue? And if you actually see the point of law in this regard is it's a continuing indemnity. Let's say, for example, my grandfather bought this land from an army brigadier in the year 1972. Now, obviously the buyer and seller, both of them are not there. But the indemnity that that the seller owes towards the buyer is something which inherits even to their legal representatives, and it will continue to any extent at any given point of time when a problem might arise. That is, let's say in 2026, there is a question that is now coming today for the first time about the title of this land. Now, my grandfather bought this. He is not there. He bought from an army brigadier. He is not there. But I am there in the capacity as as my grandfather's grandson, and the brigadier also as a family or as a legal representatives. Now, I will have to go back to them and tell them that, look, your grandfather had sold this to my grandfather, and he had agreed that any given point of time a problem will come, he will indemnify. And today, unfortunately, a problem has come. It is now time for you to come forward and help me to solve this problem. You may always ask me, is there no time limit? There is no time limit, because based on the assertion, based upon the assurances itself, my grandfather took. Now that will continue to be there as long as I am associated with the land. Let's say I have passed it on to somebody else, then the brigadier's responsibility is ended because he passed it to me. I did not use it. I have passed it on to another buyer. To the other buyer, I will become liable to ever until I am holding this land or until the other person holds his land. And there is no time limit. It is continuing. And courts have also clearly said that there cannot be a time bound, and you have to continue to honor the obligation what you have committed for.
Yeah, but will the maxim buyer beware or caveat emptor?
Absolutely not. Absolutely not, sir. Let
No,
me
the
clarify again.
seller has to make such investigation or scrutiny with regard to the title of the property that he is going to purchase. So will that not absolve even if an indemnity has been given by the seller?
Sir, correct. If you see any sale deed, we narrate that like that. We narrate that the buyer has verified the title deeds or the
Correct,
copies
correct.
of title
Yeah.
deeds, and then you do that. And like you said, we have the maxim which says, let the buyer beware. But if there are certain defects, which may also continue to be there even after verification, for those kind of defects, the seller will continue to be responsible. Now, this question of establishing falls upon the buyer. See, the seller will declare in the sale deed, I'll be responsible. But the problem will be faced not by the seller, but by the buyer. Like the example that I told, I am on this land. Any problem happens, tomorrow the government comes and says this land belongs to army, it's not a private house. They will evict me, they will throw me out of my house. I will be thrown out first. So I will have to go to the court and say that, he told me this, that he will support me. Now I am not able to reach him, or I'm able to reach him, and he had already undertaken that this is going to do about it. So this is a defect on his side, and he had promised me that any defect he will cure it. Now a time has come for him to cure the defect. So the right to claim indemnity is subjected to the buyer establishing that this indemnity is very important and that he is affected, and that indemnity is something which is covered by the seller.
Okay, thank you.
You'll have to prove that. The buyer has to prove that. So, it was a nice question, sir. I'm sure many of the other participants also must have the same kind of question. So, let me just sum up with one point and then maybe open the floor for questions. So, like we started interacting more, so be very careful about recording. So, one is how you read, second is how you understand the context, and third is how you put down. So, like the question what you were answering now about indemnity. See, there are some people, some of the clients come to me and say, why not you put a time frame to, limit the indemnification? I will say I will be liable as a seller. I will be available only for 25 years, 35 years. They come up with some suggestions. And please understand, though the real estate transaction is a commercial transaction and it's a private transaction, okay, you're not involving the government in the sense, in the sale deed, in the rent agreement, the government is not made a party about it. What you do is, if you do a registration, you're going to pay registration charges. You do a sale transaction, you want to pay stamp. That is only the fees what you pay to the government for facilitating the process of the transaction. Okay, so what I meant to say is, as a private transaction, both the parties, it can be tenant, lessor, it can be buyer, seller, it can be the bank and the borrower of loan. The parties have complete commercial freedom and the contractual freedom to word every single clause, word every single responsibility rights in their own way, suiting their convenience. But that is subject to the provisions of prevailing law. So, like I was answering, you can always tell, as a seller, I can always tell that, there's a Latin common law maxim which says you should have been aware, you should have checked this. That is a law, but there's also another point in law which says that no matter how much of verification that the purchaser does, seller is still responsible to take care about it. So, in your real estate transaction document, you cannot try to create a clause to suit your convenience, disregarding the provisions of law. That's the reason why I'm telling you. Sometimes we tend to feel to be smart and we have a drafts, we make documents disregarding certain established principles of law, disregarding established customary practices, thinking, okay, nobody's seeing, nobody's watching, let's do whatever we want. Such kind of document, even if you write it by yourself, even if you manage to get it registered, when it is questioned in the court of law, if the judge comes to know that these provisions, though you have done, both the parties have done in their own understanding, in complete freedom, if it goes against principles of law, it becomes null and void. So please understand, whenever you document transactions, have regard, absolutely you must have regard to the commercial terms. Yeah, I mean, we all know market value, guidance value is only for the formality. People always tend to buy more than that. Let's not discuss in this public forum how we split that, transaction. If you want to charge, let's say you're entering the rental transaction, you want to charge 24% per annum for every delayed rental amount, you charge it. Nobody's going to see about it. But have regard to the standing customary principles so that that makes you understand. Because ultimately, if you look at short-term gains of having recorded everything in the document and you look at and you miss out on that, when the document gets questioned, everything that has been done so far becomes null and void, and that will result in a huge financial loss for you. So, with these few words, I would want to say only two things. One, whenever you enter into transaction, please review the papers, make a list of documents, understand the context of each transaction, note down who all are involved, in what capacity are they involved, and then when you decide to go forward in the transaction to close the deal, important and one more thing I want to tell you, people tend to feel that they want to make sale date very simple, make it only for 2 or 3 sheets. Sometimes this is because they want to save the scanning charges of 1,000 2,000 rupees, or they want to save some amount of some other fees. Please understand, it's always better to elaborately narrate every single transaction, what has happened on that property. It is for your own advantage, because like I said, if you are a buyer, I would suggest make the seller record down every single transaction what they've done, so that tomorrow, if because of any of the transaction there's a problem to you, like I said, you can hold him back, because in the indemnity you can say, look, in the very same deed I've recorded everything what you have done, and this problem is coming from a transaction that you're involved, and there's an indemnity, so you better be helpful and you ensure that you cover that. So please be elaborate in your sale deed or any transaction document. Try to cover every single thing in the most simple language, most effective language, understandable and agreeable to both the parties. So these are my, few of the remarks that I would want to say and would want to end, my just discussion on this point. So you have anything to say, sir?
Yeah. So one, what I understood, suppose the seller puts that I am liable for the next 10 years. So
Hmm.
that doesn't apply basically, right?
That cannot be written at all.
Okay. Now, second question, A was at fault.
Huh?
He sold it to B.
Hmm.
Now B was a clean buyer.
Hmm.
in good faith he bought it from the A, right?
Hmm.
Now B with a good faith sold it to C.
Hmm.
C is again a clean buyer,
Hmm.
right? Now C realized later part that my document has issues.
Hmm.
So what you explained, then now you are responsible. B is responsible.
Hmm.
Now question is, can the now B can go back to A? Okay, look, it was your fault actually. How does the law work in this scenario? Like there is a chain back to back, or you become responsible for it.
Yes, yes. It's a very important question, sir. Very good. In fact, I must appreciate it. Let me tell you, unfortunately, the responsibility lies only with two people. The recent two people only will be held responsible. So in the example that you gave, A sells it to B and B sells it to C. So when B bought it itself, as somebody rightly said, B should have been aware to clear all the defects and get the document done properly. Now, when B decides to sell it to C, I know B has to ensure that everything is clear. And once B sells it to C, at the time of taking it, C had to verify everything. But what we can suggest is if C at the time of buying, before closing the deal and signing, if if C sees that transaction between A and B is not completely done, or there is some gap, there is some clarification required. Before C entering into the transaction and identifying as a purchaser, C has to convince B and ensure that you better get this thing done cleared between you and A, and then you come back to me. But if C has missed out that step also, then unfortunately C has to stand only with B and B cannot go back to A, and it has to be sorted between B and C itself.
But is
So
there
yeah. So
is
the
there is
reason,
yeah, no. So is there a way like B can still go back to A that like do something about it, or it's
you can go back, sir. There's something what is called as equity. The best example, the best thing that I can tell is equity. Equity is where even if commercial terms have all been settled, you can always say to A that look, you are morally responsible to do this, okay? Because commercially is not responsible to you because the commercial transaction between A and B got completed. And further, when B does it to C, further it is completed. So technically, commercially, A is not responsible because A is out of action. But there's something called as equity, which you have to go to the court and say that, I've been cheated upon, I've been deceived, all of those things. But it is very difficult to, because court will say it is over, it's a closed transaction. If you allow this to happen, if you allow this to happen, then, everybody will try go behind, everybody will start turning back and trying to see who is there behind their line to go start going behind their back and do that. That will be affecting all the transactions which have settled and it may not be acceptable.
I think
No,
Stephen has a question. Yes, Stephen, sir, can you please ask your question?
yeah,
Yeah.
adding to what Manoj said, just once 'cause you mentioned that at least the recent two sellers, like my predecessor in title and his predecessor in title, so
Hmm.
they will be liable. You said, but I when I purchase the property, I rely. I if I'm not a legal expert, I'll rely on some lawyer to get the scrutiny done,
Hmm.
and I'm a bona fide purchaser for value without knowing the defect in title. Even the lawyer also failed to find out the defect in title. So still, I'm see my buyer, my predecessor in title also probably may not be knowing it. So in that case, am I really liable if I sell it to Manoj? Yeah,
Unfortunately, sir, because I'll tell you the reason why this happens, sir.
yeah.
First, if at all you have done a title review, then the possibility of you doing a mistake should not occur. Because the whole task of doing a title review by a consultant or by an advocate is to ensure that you are made aware of what is to be seen, and if there's a defect, get it cured. But despite having done for whatever reason, want of negligence or want of time, whatever it is, if that has happened, and if you have relied upon that wrong advice or wrong calculation and you have gone ahead and done it, unfortunately, law will not be available to help you. Now, that is one, that is a realistic and a sad part also, I must confess and I must tell you. Now, how do we solve this problem? Now, of course, let's say, for example, in the example that Manoj sir gave, C is there, C bought it from B, B buys it from A, and like you said, maybe A bought it from Z. And if A also was bona fidely believing that title of Z was correct and took from Z, and B also bona fidely believed that A was correct and took from A, ultimately it was C's lawyer who identified that one. In the event, obviously, please understand, C will not know. Like you rightly said, from the records, it may be evident that C will get to know that B got it from A. Further, you dig upon title, you'll get to know that A got it from Z. But you cannot expect C to go behind A and Z, because he will be like, why should I spend money to go behind somebody with whom I'm not doing the dealing with? So he will shoot the bullet against B itself, because he will tell, you're in my proximity, you have to face the bullet, not anybody else. Now, what A can do is to see, to get in touch with Z and explain this has been a problem, and to see what is that they would want to offer. If not, what can be done is that in some remote cases, C can file a case against A if there's an alleged defect. And in that case, when B enters into appearance in a case which is filed by C, B will have to tell that, look, I am also sorry, I did this mistake, believing in good faith, and you have to then show the point fingers towards A. Then A will come into appearance in court, and A will say, I am also sorry, I will point fingers at Z. But this is an approach, is the only thing what you can do, but it is difficult because, see, you cannot go to the court. C only has to go to the court. Now C will go to the court and file case against B. Now B has to come to the court and tell that, B will tell to A will then tell to Z. To what extent will court believe all of those things is only a matter of debate.
Yeah,
And
yeah.
unfortunately, the court will not, I don't think court will entertain this.
Yeah, but the problem will be when the predecessors in title, they are no more. Then the C is left without tenure.
Yeah, and that is the saddest part, which is happening many a times.
Yeah. Okay, thank you.
So, Mr. Stephen Paris, can you please go ahead?
Yeah, thank you. I don't know if the scope of wills is in the purview of today's topic, or is it something I can ask now?
Scope of
Wills.
Well, yeah, please. I mean, if it is about if the will and the question is about real estate, I can be happy to
Yeah,
answer.
it's about real estate. So
Yeah.
briefly, I think in the case of there was my parents' property. So when my father passed away, my sister, who's all of them are older to me, so she made a will wherein she got it what do you call notarized? Not notarized. What is that? Registered. I'm sorry, registered, and it was equally split between the four of us, four siblings, right? Now, a couple of years later, my elder brother, he decided to make a second will, where he said, okay, this is the latest will with my mother, and then he removed one of the siblings out of the property, and and it's not registered. So now the question is that one which takes precedence. I think, to my knowledge, it's the second one, even though it is not registered, right? If the second will is the one which is the latest and takes precedence, then the thing is, of course, we have to go through this family tree, which I know my sibling or my elder sister who's been left out will of course object to it, right? So how to proceed in such a scenario? Because from my point of view, I'm okay with all of us getting an equal share, but he is kind of decided because he's the one who had drafted the will and got my mother to sign it. So now he has, for whatever reasons, excluded my elder sister. So any advice on this that would help me?
Yeah, sure. May I know if your mother is alive?
No, she passed away.
Okay, sorry. Okay, after she passed away, what has been the status as of now?
Status as of now is we're still not, what do you call, it's been 11 years. I'm still trying to get a resolution to that. And he is basically dragging his feet in terms of execution. Because one of the sister who actually wrote the first will, she's still residing on the property. So, so his contention is, okay, now she has to stay there. And, it's like status quo, and he's basically using that as a scapegoat
Yes,
to
yes.
kind of say that we can't execute on
Yes,
the will. So
yes.
it's been 11 plus years, and I want to proceed on that. And yeah.
Yes, yes, yes. Thank you, sir. I think this is a very important question, which I'm sure this may also give answers to many of the others who are also here, because at some point of time we must also understand that we might be dealing with apartments or land which belongs to a family, and one way or the other way, will would be a document which is there. So I'm sure this will also try to give idea to others also. So generally, what happens is that, as we know, will is a personal aspect, that is which is to be decided by a person in his or her private capacity. Nobody can compel a person to make a will. Okay, so that's the reason why if you see a will, it always starts with the opening statement telling, I am so and so, and I'm making this will with complete free mind, and I'm not coerced. I'm competent to do all of those things.
Correct.
And
Yeah.
second is, since it is done in the private capacity, and it is done something which a person wants to spell out a desire, I mean, spell out the way how the properties, assets have to be, to be divided, and it takes into effect after their demise when they're not there. They will try to make it very specific. So I'm sure you'll understand. See, when I want something to be done, and I want to witness that event, I will make sure that I convey the way how the event should be done to my associates and tell them this is what I want it to be done. And when I go to the event, when I find that the event is not executed in the way that I want it to be done, then and there I will scold, I'll somehow manage to get things done and make the event happen in the way how I want it to be there. As against this, when I want my assets, my properties to be divided after I die, I will obviously not be there to see how they will divide it. So the beauty of will is the best will is something which is very elaborate, which is clearly specifying everything in detail. Who should get how much, how should the divide it, and if there are many assets, you can divide all about this. That is the reason why the law has given liberty to people to make multiple wills, because it is a person's choice, and person's choice and the preferences, perceptions about people are tend to change. Today, I might have a favoritism, I might have a positive opinion about somebody, but due to some reasons my opinion can change. So I might have a very good friendship with somebody else, I might want to give them something in return even after I die, but maybe after I write and close it, situations might go bad against both of us. I would want to, why should I give something which I own to him, and I might want to withdraw it back. This is the reason why law allows you to keep on revising your will. And that's the reason why law says if you've done multiple wills as per the provision of law, the latest one that is made only is going to prevail. The reason behind this is this, because people tend to change, interactions will change. With more interactions, you'll get to know people better, all of those things, so you get to change about it. Now, because it is subjected to so much of change, law also did not mandate it to be registered. Because see, if I do a will today, register it. Tomorrow again I change my, I have to again go to the government and do that one. And further, a person can make a will. Unless we are educated, we are well planned in life, we make a will. But somebody who is not so educated, not, I mean, in events when they're inching nearer to death, they may want to make a will then and there with whatever they have. So registration is not mandatory. So registration is not mandatory. You can have multiple wills. Latest one will prevail. In a scenario when there's a dispute between registered will and an unregistered will being the latest one, as per the law, the unregistered will only will prevail. Okay, that is the understanding, because latest one is going to be prevailing over that. But the registered will has a unique standing. Okay, a registered will is always regarded as a very high evidentiary standard. Okay, so though in law, registered versus latest one will prevail. But when you go to the court and subject the registered will and the unregistered latest will, court tends to draw a favorable opinion in support of a registered will only because it has the stamp of registration and it has gone through a process. Now, that does not mean that the court will not consider the latest will which is unregistered. Now, it will be the task of the person who is relying upon latest will to prove why did that second will come. And when that second will came, why was that second will not registered when the first will was registered? Okay, so here it is a systematic way of trying to establish the burden of proof. So in law, we call it as burden of proof. If let's say between me and my sister, I am relying upon registered will which says my grandfather gave this. And she is relying upon unregistered will which says that my grandfather gave it to her. I will go to the court and tell that I have registered will in which my name is there. She will come to the court and say, no, no, it is unregistered last will. He stayed with me during his last days and he's given it to me. Now, I will have to convince the court as to so she has to convince the court as to why he chose to come and live with her. Why did he choose to make a will after having a registered will? And what made him, or what compelling situation was there which made him unable to do the registration? That is how this has to be handled in the court. If not, I would suggest, in the interest of your family members, to see if a settlement could be arrived so that all of you can sit down and discuss.
Yeah, I think that would be the best alternative instead of going to the court and paying legal fees, right? So, and it's a long drawn affair.
Yes.
I
It
understand
will
that, yeah.
ultimately solve the relations also.
Yeah, because the problem here is the second will, which is the latest will and which is unregistered, she was already old. And now the question is, to my knowledge, my mother would not have left out one of her own children. So
Exactly.
it's intentionally done by
Yes,
my brother
yes,
to leave one of the sisters out of the deal because he
yes,
had a
yes,
conflict with her.
yes,
So that's why I
yes,
kind of doubt the authenticity of the will written.
yes.
And even
Perfect,
though
perfect.
even
You're
though
on the
he
right
says
track.
that, yeah, even though he says that the person who drafted the will is not him, but it's somebody else. So I mean, knowing my mother had dementia, and it's highly impossible that she could have said yes to, yeah, she'll say yes to anything practically,
Yes,
right? So it's
yes.
that's why I kind of but is court, I mean, I know out of court settlement is the best, but if it goes to court, is this a long drawn affair or is it a quick execution? How long?
It will be a long drawn effort, sir, because you have to understand that it is a registered will and you have an unregistered will. So we'll have to put the will to the question. Registered will, we have to call the witnesses. If the witnesses have signed, we'll have to call them to examine them. Unregistered will, who claims, has to come and say why it is it is definitely a long drawn matter. Be rest assured, it would take around 2 years to solve this.
Oh dear. Okay. All right. Thank you so much.
Yeah, I think we have exceeded the time. Manoj, I think you're saying something, you're
I
on
have a
mute.
question, sir. Can I ask?
Yeah, yeah. I mean, I need to ask the organizer's permission first. Sir, can I take this as the last one? Okay. Please go ahead.
Yeah. So in the family tree, like my husband has two sisters and totally three siblings.
Hmm.
And two sisters, out of that, one sister is no more and she did not have any issues also. And her husband is also no more. So, but her name is in the family tree. I want to know about the legal heirship when we transfer the property. First question.
Go ahead.
So it's only the survival members come to thing, or still she is a legal heirship holds good?
No. I mean, from what I understand, she is one of the legal heirs, no? I mean,
Yeah,
she is
one of the
related.
legal.
Yeah,
Yes,
she is
sir.
related to your husband.
Yeah, she's a sister.
Okay. And
And
she was married.
yeah,
Okay. Her husband is not there.
she's also not there, and they don't have children.
So what is your doubt, ma'am? Because let's say you plan to dispose of family property and
Yeah,
you have shown her as the legal heir. And
yeah.
in her place, you just have to tell to your prospective buyer that show the death certificate and say that she is no more. And if they were to ask, was she married, you will show your brother-in-law's, your husband's brother-in-law's death certificate and say that he is also no more. And since they have no children, they will also not have any, they will also not come into picture. So you can just say that your husband has husband had one sister who was married. Unfortunately, she is not there. She had no issues. Her role will not come into picture at all.
Yeah, but if we have no connection with the husband long back, like we don't have his death certificate or something.
Oh,
Hmm.
okay.
Yeah.
So I mean, see, if it is, I understand your concern now. If he is also not there, but you don't have his death certificate, is what you're
Yeah.
telling.
Yeah.
Okay. Then you can write. You can make a family tree and say that your sister-in-law, your father, sorry, your husband's sister. You can mention the her husband's name and you can write bracket deceased late and leave it like that. If they were to ask a clarification, say that he also died and they both have no children. That's all.
One more question I have, sir. Thank you for that. And in a property like it's a 60 by 120 site, half of the site was sold when my father-in-law was there. So now he's no more, and my husband is also no more. So that it has to be transferred to me now. So in this case, the one more sister is there. So how it is in the still in the panchayat, but the panchayat has been now recently transferred to city corporation, that area. How do I go about it? So they're saying like you have to go for e-Khata. I'm very new to it. So how to go about it? When I checked the documents, it had the sale deed which they had sold half of the site to only that sale deed I have, and rest of the documents what they had asked for, that is plan or tax receipts, all that is in my husband's name only. Tax receipts and the kata is also in my husband's name, so name only. Please give me advice like how to go about it, sir.
So, see, you're talking about only the reminder portion, no? Because half of it is sold to somebody else. Okay.
Yeah. Hmm.
Then you're only a owner for the half. Your husband was owner for the half.
Yes, sir.
And the sale happened during his lifetime.
Pardon, sir?
The sale of the half of the portion happened during your husband's lifetime.
Yeah.
Okay, nothing to worry. So now you will be owner. I mean, your husband would have continued to be the owner for the half portion. And since he is no more, may I know if you have children?
Yes, I have one son.
Okay. So in that case, what happens is you will have to approach to the the municipal corporation area limits and show them the original sale deed through which your father-in-law got the property, and then
Okay.
tell them that after he died, it came to your husband, and produce death certificate to say that he is not there, and say that you are the wife and you have a son, and get the property documents mutated, that is converted to your name, and then parallel you can also apply for e-Khata into your name.
Yeah, out of the two sisters, one sister is there. So one sister is expired, as I told earlier. One sister
Okay.
is there.
Okay. Anyway, see, if you are planning to dispose it, it's another thing. Then you will need their permission, approvals and all. If you're only
Okay.
planning to get the property records transferred to your name, you don't need their involvement because
Oh,
it was your father-in-law's, then it came to your husband, and then it's coming to you. So you're only changing the names. When you're disposing, then the buyer will insist on conditions like getting NOC from your sister-in-law, whoever is alive, all of those things. But for change of name in the records, I don't think you will be need to involving a sister-in-law at this moment.
okay, sir. Thank you so much.
Yes.
Uh, Right. Thank you everyone for joining us today. We hope this session helps simplify the legal aspects of real estate documentation and give you a greater confidence in navigating property transactions. Special thank you to Dr. Abhishek Sharma for sharing his valuable expertise and addressing a wide range of legal questions. And as a gesture of appreciation, we would like to gift you 2 silver coins, and we would also plant a tree on your and your loved one names. Thank you so much, everyone.
Thank you. Thank you so much, Manoj sir, for having me here, and thank you for all your team for coordinating with me and having me here. And most important, thank you for the audience for being so patiently with me and interacting. It was indeed a wonderful session. Loud meeting, I mean, virtually meeting all of you, and hope at some point of time you're able to grow successfully in real estate. Be careful with your transactions.